Trade Boards Act 1918, 8 and 9 George V, c. 32. Section 1, subsection 1. The Trade Boards Act 1909, in this Act referred to as the Principal Act, shall apply to the trades specified in the schedule to this Act and to any other trades to which it has been applied by a provisional order made under Section 1 of that Act or by a special order made under this Act by the Minister of Labour, in this Act referred to as a special order. Subsection 2. The Minister of Labour, in this Act referred to as the Minister, may make a special order applying the Principal Act to any specified trade to which it does not at the time apply, if he is of opinion that no adequate machinery exists for the effective regulation of wages throughout the trade, and that accordingly, having regard to the rates of wages prevailing in the trade or any part of the trade, it is expedient that the Principal Act should apply to that trade. 3. If at any time the Minister is of opinion that the conditions of employment in any trade to which the Principal Act applies have been so altered as to render the application of the Principal Act to the trade unnecessary, he may make a special order withdrawing that trade from the operation of the Principal Act. 4. If the Minister is of opinion that it is desirable to alter or amend the description of any of the trades specified in the schedule to the Principal Act, he may make a special order altering or amending the said schedule accordingly. 5. Any act confirming a provisional order made in pursuance of Section 1 of the Principal Act may be repealed or varied by a special order. Section 2, subsection 1. Every special order shall without confirmation by Parliament have effect as if enacted in this Act and may be varied or revoked by a subsequent special order. 2. The provisions contained in the first schedule to this Act shall have effect with respect to the procedure for making special orders. 3. Where the Minister makes any special order, he shall publish it in such a manner as he thinks best adapted for bringing it to the notice of all persons affected thereby, and the order shall come into operation on the date on which it is so published or on such later date as is specified in that behalf in the order. 4. Every special order shall be laid before each House of Parliament forthwith, and if an address is presented to His Majesty by either House within the next subsequent 40 days on which that House has sat after the order has been so laid, praying that the order may be annulled, His Majesty may annul the order, and it shall thenceforth be void, but without prejudice to the validity of anything previously done thereunder or to the power of making a fresh order. First Schedule, subsection 6. The Minister may appoint a competent person not in the employment of any government department to hold an inquiry with regard to any draft order and to report to him thereon. 7. The inquiry shall be held in public, and such officer of the Ministry of Labour as is appointed by the Minister in that behalf, and any objector or other person who appears to the person holding the inquiry to be effected, may appear at the inquiry either in person or by counsel, solicitor, or agent. 8. The witnesses at the inquiry may, if the person holding it thinks fit, be examined on oath. 9. Subject as aforesaid, the inquiry and all proceedings preliminary and incidental thereto shall be conducted in accordance with regulations made by the Minister. Education Act 1918, 8 and 9 George V, c. 39, Section 34, subsection 1. A local education authority may be authorised to purchase land compulsorily for the purpose of any of their powers or duties under the Education Acts by means of an order submitted to the Board of Education and confirmed by the Board in accordance with the provisions contained in paragraphs 1 to 13 of the first schedule to the Housing, Town Planning, etc. Act 1909. And those provisions shall have effect for the purpose, with the substitution of the Board of Education for the Local Government Board, of the Local Education Authority for the Local Authority, and of references to the Education Acts for references to this Act. Ministry of Transport Act 1919, 9 and 10 George V, c. 50. Section 11. An appeal shall lie to the Minister of Transport in respect of any restriction upon any traffic passing over or seeking to cross any bridge or culvert, and the Minister shall have power, notwithstanding any provision in any other statute, to make such order as he may think fit concerning the strengthening, standard of maintenance, and maintenance of any bridge or culvert, the traffic using it or seeking to use it, and apportionment of any expenditure involved, but no order made by the Minister under this section shall enlarge the pecuniary liability of any railway or canal company or impose any new liability on any such company. Section 29, subsection 1. The Minister may make rules in relation to matters preliminary to the making of orders and orders in council under this Act which authorise the acquisition of land or easements, or the breaking up of roads and the construction of works, including the publication of notices and advertisements, and the deposit of plans and sections and books of reference to those plans, and the manner in which and the time within which representations or objections are to be made, and to the holding of local inquiries. Any rules so made shall be laid before Parliament as soon as they are made, and shall have the same effect as if enacted in this Act, provided that, if an address is presented to His Majesty by either House of Parliament within 21 days on which that House has sat, next after any such rules are so laid, praying that any such rule may be annulled, His Majesty may annul the rule, and it shall thenceforth be void, but without prejudice to the validity of anything done thereunder. Animals (Anaesthetics) Act 1919, 9 and 10 George V C54. Section 3 subsection 1. The Board of Agriculture and Fisheries may, by order made subject to the provisions of this section, add any other operation to the operations specified in any schedule to this Act, and any operation so added shall be deemed to be an operation specified in that schedule, and may transfer an operation from one schedule to another, and the Board of Agriculture and Fisheries may also, by order made as aforesaid, extend any provision of this Act to any domestic animal to which it does not at the time apply, with such modifications or additions as may appear to that Board to be necessary. The Board may, by order made subject to the provisions of this section, declare any substance to be a suitable general anaesthetic or a suitable local anaesthetic for the purposes of this Act, and any substance so declared shall be deemed to be a general anaesthetic or local anaesthetic, as the case may be, of sufficient power to prevent the animal feeling pain if properly applied. 2. The draft of any such order shall be published for a period of 3 months before the order is made, and the Board of Agriculture and Fisheries during that period shall receive and consider any representations made to them with respect to the order by any persons appearing to them to be interested in the subject of the order. 3. The order, when made, shall forthwith be laid before Parliament, and shall not take effect until it has so lain for 30 days before each House of Parliament, being days upon which that House has sat, and if a resolution is passed by either House before the expiration of such days declaring that the order be annulled, the order shall not take effect, but if no such resolution is passed, the order shall take effect on such day after the expiration of the last day on which any resolution might have been passed as the Board of Agriculture and Fisheries may appoint. Housing (Additional Powers) Act 1919, 9 and 10 George V C99, Section 5 subsection 1, where it appears to a local authority that the provision of dwelling accommodation for their area is or is likely to be delayed by a deficiency of labour or materials arising out of the employment of labour or material in the construction within their area of any works or buildings, other than works or buildings authorised or required by, under or in pursuance of any Act of Parliament, and that the construction of those works or buildings is in the circumstances of the case of less public importance for the time being than the provision of dwelling accommodation, the authority may by order prohibit for such time and on such terms and subject to such conditions as the Minister of Health may from time to time prescribe, and either in whole or in part, the construction of those works or buildings. 2. Any person aggrieved by an order made by a local authority under this section may, subject to rules of procedure to be made by the Minister, appeal to the Minister, and on any such appeal the Minister shall refer all such cases to a standing tribunal of appeal, consisting of 5 persons to be appointed by the Minister, which shall have power either to annul the order or to make such order in the matter as the local authority could have made, and the decision of the tribunal of appeal in the matter shall be final and not subject to appeal or to review by any court. 4. If any person acts in contravention of or fails to comply with any of the provisions of an order made under this section, he shall be liable on summary conviction to a fine not exceeding £100, and if the offence is a continuing offence, to a fine not exceeding £50 for each day during which the offence continues, and, where the person guilty of an offence under this section is a company, every director and officer of the company shall be guilty of the like offence unless he proves that the act constituting the offence took place without his consent or connivance. Section 6, subsection 1. If any person at any time after the 3rd day of December 1919, without the permission in writing of the local authority within whose area the house is situate, demolishes, in whole or in part, or uses otherwise than as a dwelling house, any house which was at that date, in the opinion of the local authority, reasonably fit or reasonably capable without reconstruction of being rendered fit for human habitation, he shall be liable on summary conviction in respect of each house demolished or so used, to a fine not exceeding £100, or to imprisonment for a term not exceeding 3 months, or to both such imprisonment and fine, and, where the person guilty of an offence under this section as a company, every director and officer of the company shall be guilty of the like offence unless he proves that the act constituting the offence took place without his consent or connivance. 2. Any person to whom permission to demolish a house has been refused by a local authority under this section may appeal to the Minister on the ground that the house is not capable without reconstruction of being rendered fit for human habitation, and any such appeal shall be dealt with in the same manner as an appeal under subsection 2 of the preceding section of this Act. Electricity (Supply) Act 1919, 9 and 10 George V C 100, Section 5, subsection 1. The Electricity Commissioners may provisionally determine that any district in the United Kingdom shall be constituted a separate electricity district for the purposes of this Act, and, in considering what areas are to be included in a district, areas shall be grouped in such manner as may seem to the Commissioners most conducive to the efficiency and economy of the supply of electricity and to convenience of administration. Before finally determining the area of any such district, the Electricity Commissioners shall publish notice of their intention so to do, and of the area proposed to be included in such district, and shall also give notice thereof to all county councils, local authorities, and authorised undertakers any part of whose county district or area of supply is proposed to be included in the electricity district, and, if any objection or representation be made on account of the inclusion in or the exclusion from the proposed district of any area, the Electricity Commissioners shall hold a local inquiry with reference to the area to be included in the proposed district, provided that, where a local inquiry is held as hereinafter provided regarding the improvement of the organisation of the supply of electricity in any district, the area of that district shall not be finally determined until after that inquiry has been held. 2. Where it appears to the Electricity Commissioners, with respect to any electricity district so provisionally determined that the existing organisation for the supply of electricity therein should be improved, the Commissioners shall give notice of their intention to hold a local inquiry into the matter, and shall give to authorised undertakers, county councils, local authorities, railway companies using or proposing to use electricity for traction purposes, large consumers of electricity, and other associations or bodies within the district which appear to the Commissioners to be interested, an opportunity to submit, within such time as the Commissioners may allow, a scheme or schemes for effecting such improvement, including proposals for altering or adjusting the boundaries of the district, and, where necessary, the formation of a joint electricity authority for the district. 3. If no such scheme is submitted within the time so allowed, or if no scheme submitted is approved by the Commissioners may themselves formulate such a scheme. 4. The Electricity Commissioners shall publish, in such manner as they think best adapted for ensuring publicity, any scheme which they have approved, with or without modifications, or which they have themselves formulated, and shall hold a local inquiry thereon. Section 6, subsection 1. A scheme under the last foregoing section may provide for the establishment and, where desirable, the incorporation with power to hold land without licence in mortmain of a joint electricity authority representative of authorised undertakers within the electricity district, either with or without the addition of representatives of the council of any county situate wholly or partly within the electricity district, local authorities, large consumers of electricity, and other interests within the electricity district, and, subject as hereinafter in this Act provided, for the exercise by that authority of all or any of the powers of the authorised undertakers within the electricity district, and for the transfer to the authority of the whole or any part of the undertakings of any of those undertakers, upon such terms as may be provided by the scheme, and the scheme may contain any consequential, incidental, and supplemental provisions which appear to be expedient or proper for the purpose of the scheme, including provisions determining the area included in the electricity district, provided that no such scheme shall provide for the transfer to the authority of any part of an undertaking except with the consent of the owners thereof. 2. The scheme may provide for enabling the joint electricity authority to delegate, with or without restrictions, to committees of the authority any of the powers or duties of the authority, and for the payment out of the revenues of the authority of travelling and subsistence expenses of members of the authority, and reasonable compensation for loss of remunerative time. Section 7, subsection 1. The Electricity Commissioners may make an order giving effect to the scheme embodying decisions they arrive at as the result of such inquiry as aforesaid, and present the order for confirmation by the Board of Trade, who may confirm the order either without modification or subject to such modifications as they think fit. 2. Any such order shall be laid, as soon as may be after it is confirmed, before each House of Parliament, but shall not come into operation unless and until it has been approved either with or without modification by a resolution passed by each such House, and when so approved shall have effect as if enacted in this Act. 3. An order made under this section may be altered by a subsequent order made, confirmed, and approved in like manner as the original order. Section 12, subsection 3. Subject to the limitations hereinbefore contained on the powers of a joint electricity authority to supply electricity, the Electricity Commissioners may, by order, after such inquiry as they think fit, impose on any joint electricity authority an obligation to supply electricity in such circumstances, within such areas, and on such terms and conditions as to price and otherwise as may be specified in the order. Section 34, subsection 1. The Board of Trade and the Electricity Commissioners may respectively make rules in relation to applications and other proceedings before them under this Act, and to the payments to be made in respect thereof, and to the publication of notices and advertisements, and the manner in which and the time within which representations or objections with reference to any application or other proceeding are to be made, and to the holding of inquiries in such cases as they may think it advisable, and to the costs of such inquiries, and to any other matters arising in relation to their powers and duties under this Act. 2. Any rules made in pursuance of this section shall be laid before Parliament as soon as may be after they are made, and shall have the same effect as if enacted in this Act. Section 35, subsection 1. A special order made under this Act by the Electricity Commissioners shall not have any effect unless and until confirmed by the Board of Trade. Subsection 3. Before any special order, other than a special order which is not valid unless approved by a resolution passed by each House of Parliament, comes into force, it shall be laid before each House of Parliament for a period not less than 30 days during which that House is sitting, and, if either of those Houses before the expiration of those 30 days presents an address to His Majesty against the order, or any part thereof, no further proceedings shall be taken thereon without prejudice to the making of any new order. Subsection 4. A special order so made and confirmed as aforesaid shall have effect as if enacted in this Act.